All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're on the record now in case CV15-0280, Cantex, Inc., v. Princeton Excess and Surplus Lines Insurance Company. This is the time for oral argument. And counsel for appellant is going to be Mr. Davis.
Mr. Davis, Your Honor.
Okay, and then counsel for appellee is Mr. Welker.
Yes, Your Honor.
Okay, those are easy names for me to pronounce.
You can still mess them up.
There's always potential. Counsel, let me just advise you that we've read your briefs carefully. We've discussed the case, so we're very familiar with the issues. You each have 20 minutes to present your argument. Mr. Davis, you just let us know if you want to set aside some time for rebuttal argument. You certainly can do that. I do want to advise you both that these proceedings are being audio and video recorded, and then they're uploaded to our website in the next couple of days. So just be aware of that. With that being said, Mr. Davis.
Thank you, Your Honors, and good morning. My name is Gregory Davis. I'm joined by my colleague today, Gregory Schneider. We represent the plaintiff appellant in this case, Cantex, Inc. I'd like to reserve 3 minutes for rebuttal, please.
Of course.
Your Honors, there are 3 points that I'd like to make this morning. The first is that the trial court's interpretation of the insurance policy was contrary to its plain and ordinary meaning. Second, the trial court's interpretation was unsupported by the minimal evidence in the record here. And third, the trial court erred by even considering the merits of the motion for summary judgment on the limited record because Cantex wasn't given a reasonable opportunity to present pertinent material. With respect to the policy language, the product's completed operation hazard provides that it's triggered when the pavement is put to its intended use by someone other than...
Mr. Davis, can I ask you to slow down just a little bit?
Of course, Your Honor.
I know you can...
I'm
trying to listen to what you're saying. Just slow down a little bit.
Absolutely, Your Honor. So the product's completed operation hazard, which is the policy provision that we're here to discuss, provides that the pavement is complete when it's put to its intended use by anyone other than a contractor working on the same project. There's no evidence in the record here that the manner in which Cantex used the pavement during the policy period, which was to support vehicular traffic and to store inventory, is anything other than the exact manner in which Cantex intended to use the pavement, nor is there...
It's not use of the payment, is it? It's use of the work.
It's use of that particular part of the work,
Well,
Judge
there's
Downey.
another part of the policy that I know talks about the partial completion and use, but doesn't this have to be use of the work for the exception to the exclusion to apply?
Respectfully, no, Your Honor. And I think we're conflating, as the trial court conflated it and as Peslick conflates, the certificate of substantial completion, which is referenced only in a construction contract, and the insurance policy.
Well, I'm just looking at the policy language, and you may be right, but the policy language is when that part of the work done at a job site has been put to its intended use. So when you say the pavement, I think you're taking a little bit of a cheating step by making a smaller bite versus the work, aren't you?
I don't think so, Judge Downey, and I think that's apparent if this is from Appendix 123. If you look at subsection A of the product's completed operation hazard, there's actually 3 ways that the work can be deemed complete. One of the first ways is when all of the work called for in your contract is complete. Subsection C, which we're here to discuss, talks about that part of the work. So there is a lesser part, and Peslick, in its briefs, acknowledges that completion of or intended use of a lesser part of the work constitutes complete. So I don't think that's a disputed issue here today. So there's no evidence in the record that the manner in which Cantex used the pavement is in fact any different than the manner that it's used the pavement each and every day during the plant's life. That's exactly the sort of evidence, however, that Peslick would need to present if it were to demonstrate beyond any genuine dispute that coverage is excluded here based on the plain and ordinary terms of the insurance policy. The insurance policy doesn't reference.
If I follow you correctly, you're arguing that the term intended use is not, I mean, I guess everyone agrees, it's not defined in the policy.
That's exactly right, Your Honor.
Peslick says it's defined in the contract, and we should look to the overall transaction, which includes both the policy and the contract. And I guess they're probably saying in the A and B that you just referenced a minute ago, you referenced A, there's a reference to your contract, which has to be the construction contract.
Correct.
So I guess they're saying, are they not, that obviously the construction contract is in view here when we look at the insurance policy language, and so it makes perfect sense to go from the intended use in the insurance policy to completed to substantial completion and intended use in the construction policy.
I think there's a couple of responses to that. The first is that if the insurer and the insured here, ORIC and RBR, intended to refer to the contract, they plainly knew how to do that. They did that in subsection A. And also the idea that the contract here is in view of the insurer and the insured when they drafted their policy is contrary to the facts. The Cantex RBR contract was not even in existence at the time that the ORIC policy that we're discussing was issued. The policy doesn't say substantial completion, and it certainly doesn't condition the triggering of the product's completed operation hazard on a certificate of substantial completion first being issued. The judge suggested that that condition could be implied into the policy because, according to the judge, the insurance contract and the construction contract mimic one another with respect to their definition of complete. And I would submit that that conclusion is both legally wrong and it's factually wrong. It's legally wrong because one contract can't incorporate another contract by implication. It has to be clear, has to be unequivocal, and it wasn't here. And secondly,
It's not enough, you're arguing, that it references your contract in the standard insurance policy language that is here. That's not enough.
Well, in fact, Your Honor, and in subsection C that we're here to discuss, it doesn't even reference your contract.
Oh, but it does in A and B.
That's correct, and I think that distinction is important, that if the insurers intended to incorporate the contract, they knew how to do so with respect to subsections A and B. They chose not to with respect to subsection C, and we have to respect that decision by the insurer and the insured.
So if we were dealing with an issue under A and B of this product completed operations definitional section, you would acknowledge that the reference to your contract would be sufficient, but you're underscoring that there's no reference to your contract, the words your contract, in subsection C.
Certainly, if we were here to discuss subsection A, then the question of which contract is being referenced in subsection A would be important, and the question of when all of that work is complete would be important. But that's, again, we're not here to discuss that. We're here to discuss when the pavement was put to its intended use. And the trial court suggested that one could imply that the substantial completion definition it controls that question of when it's put to its intended use because the trial court believed that the language mimicked one another. They don't. Substantial completion under the construction contract and completion under the insurance policy have very different sets of requirements. First, substantial completion requires that an owner receive certificates of occupancy, permits, approvals, licenses from the governmental authority, all of these conditions that don't exist in the insurance policy. That's Appendix 105, the construction contract. Another example is that...
And it requires an AIA document certified by the architect, right, as we had here in December. In this case, substantial completion.
Of course,
under the contract.
That's correct, Your Honor.
Construction contract requires that.
That's correct. It requires the insured to call an architect to come out from Texas, an architect to walk the site, an architect to issue a certification.
But the fact that the construction contract and the architect's certificate of substantial completion use the phrase intended use, there's still no tie-in or carryover.
Absolutely not, Your Honor. Intended use should be given its plain and ordinary meaning in both contexts, both in the context of the certificate of substantial completion and in the context of the insurance policy. But the words around that phrase, intended use, matter. And so the trial court's suggestion here, and Peslick's suggestion, that intended use and substantial completion are synonymous is just wrong. Intended use, that the pavement be available for its intended use, is but one of many requirements that's necessary for substantial completion to be met. intended use is a prerequisite for substantial completion, not the other way around, as Peslick suggests. And all of the case authority that the parties have presented here, Your Honors, confirms that the determination of when work has been put to its intended use for the purposes of the product's completed operation hazard turns on the manner of use, not on whether certain construction documents have first been issued. And in fact, Peslick hasn't cited any case from any jurisdiction at any level in which a court has concluded that work can only be deemed to have put to its intended use for the purposes of the product's completed operation hazard if a certificate of substantial completion has first been issued.
Have you located any case on facts like this that have said, no, we see some similarity in the language from the construction contract and the insurance policy, but we're not going to use the construction contract language. We're going to instead declare this a factual issue?
Well, this evidence isn't in the record for reasons that we'll discuss later, but Peslick suggests that AIA construction contracts are the norm.
Can I ask you a question, counsel?
Yes, Your Honor.
What sense does it make to incorporate the language from the contract only as to 2A and 2B and not as to subsection C? I mean, if your argument is the reference to your contract in subsection A and B is fair game to say what completion is in the contract applies to A and B, are you saying that somehow this policy has a different definition under the same subsection, under subsection or section 2, that they're talking about what's completed work on the contract in A and B, but then they want to go outside the contract and go to some other meaning of what intended use is and what completion is under subsection C? Why would they write it like that?
Well, they would do that because of the coverage that the insured is purchasing here.
They're going to have two different kinds of coverage within the same section here under section 2? They're going to talk about what completion is differently in the same contract?
No, Your Honor. There's one type of coverage, and it's met 3 different ways. What the product's completed operation hazard really is, this is completed work coverage.
I understand that.
So there are 3 ways in which RBR's work can be deemed
The issue
complete.
here is when the work was completed. We understand that. That's the factual issue. So then what does this mean here? What does this subsection mean? And I think you've, I don't want to put words in your mouth, but I think you've somewhat conceded that under the product's completed operations hazard, subsections 2A and B, referencing the contract, incorporate what the completion of the work is under the contract. But then you're saying under subsection C, there's some other definition of when the work's completed under the contract. Is that what you're arguing?
I think there are 3 definitions under the product's completed operation hazard for when the work is complete. And I think
shouldn't we read the section together as a whole and look at the language as a whole to see what they were talking about in terms of when the work was complete?
Absolutely, Your Honor, and I think you do by recognizing and acknowledging the choice by the insurer and the insured to say, listen, your work is going to be complete when you finished everything under your contract, irrespective of anyone sets foot on it. The owner doesn't have to use it, another subcontractor doesn't have to use it, but your work is also going to be complete if someone puts it to its intended use. The insured here can't just forego getting a certificate of substantial completion.
Right, but under your reading of it, then the way we would read it is under 2A, we look to the contract because 2A references your contract. So the work's completed when there's substantial completion, and there's the architect's certificate. Under 2B, we would look at the work completed because it says your contract, and we would look to substantial completion. And then in the same policy provision under C, we wouldn't look at the contract at all, and we would go to some other definition about when the work was completed. Is that the construction that you're arguing?
You would look to the plain and ordinary definition, but yes, Your Honor, and I think that's the construction that this court itself has held in the Colorado casualty case. In that case, there was no dispute that the work, it was a highway construction case. There was no dispute that the highway work wasn't done. But what the court looked at, this court looked at is when the work, which was putting up these concrete barriers, when it had been put to its intended use. And this court concluded that the concrete barriers were put to intended use the minute they were placed there and they divided the traffic, irrespective of the fact that the entire contract wasn't done. And this court concluded that's the correct conclusion because that's what the plain and ordinary meaning of put to its intended use means. And
But doesn't your construction create like an inherent conflict in the policy about when the work's complete? Because it may mean when there's substantial completion of the contract, but under C, it may not mean that. I mean, don't we have to, don't we have to try to read these to make sense out of the language?
Your Honor, I'm sorry. These are alternatives. It says the earliest of. So no, I don't think there's an inherent conflict because whichever one arrives first is when the work will be deemed complete and the hazard is triggered. Okay. Now here, Peslick isn't even arguing that the plain and ordinary meaning of the phrase "put to its intended use" supports its conclusion. It's saying that Cantex and RBR reached an agreement. That Cantex and RBR agreed that there would be this special definition. But there's no evidence of that.
Through the construction contract.
Through the construction contract, of course. But there's no evidence of that. There's no deposition testimony. There's no declaration or affidavit. There's only, as Your Honor noted, the construction contract. But it doesn't define intended use. It defines substantial completion. And as we've explained, those are different terms. And I think even another reason that demonstrates Peslick's argument is wrong is it requires Your Honors to conclude that ORIC made a $1 million mistake here. Peslick is an excess carrier. Its policy incorporates Old Republic Insurance Company, ORIC's primary policy. This phrase, put to its intended use, that we're grappling with, that's not found in Peslick's policy. It's found in ORIC's policy.
I'm not sure I get your point there.
My point is that
the Peslick policy is the following form.
ORIC paid, Your Honor. ORIC paid $1 million.
Well, they may have paid to avoid a bad faith claim, who knows what.
Certainly, Your Honor, they may have paid for any number of reasons, but it's a reasonable inference. It's reasonable to conclude that ORIC paid because there's a possibility of coverage under its policy. Peslick's argument and ORIC having paid are totally irreconcilable, and that fact alone would warrant reversal of the grant of summary judgment. But this court need not even reach the substantive error that the trial court made because there is a significant procedural error that the trial court made, and that was converting this case from a motion to dismiss to a motion for summary judgment and granting it in Peslick's favor without giving Cantex a reasonable opportunity to present pertinent material. 12B is quite...
Did Cantex at that time, at that oral argument, did Cantex say, wait a minute, Judge, we need to present more information to you, or did it file a Rule 56F or some other kind of motion there immediately thereafter saying we need to present more information?
Your Honor, I wish I would have had that opportunity. Unfortunately, we presented the argument as a motion to dismiss. The parties presented their argument. They sat down. And at that point, the trial court converted it from a motion to dismiss to a motion for summary judgment and immediately granted it. There is quite literally no opportunity for Cantex to present any evidence, for Cantex to file a Rule 56 motion, for me to even make argument demonstrating why summary judgment wasn't appropriate here. And I think that, Judge Downey, your opinion in Young v. Rose is on all fours here. In that case, the...
Don't stroke her. It's hard enough. We can't have that.
In that case, Your Honors, the plaintiff attached documents that were outside the pleading to respond to a motion to dismiss. The trial court considered those documents. It nevertheless ruled in defendant's favor, saying that there was no issue, no claim as a matter of law that has been made, and Judge Downey, writing for this court, vacated that judgment.
Let me ask you this, because as I read your appellate briefing, you say that the area that you would have supplied additional information regarding is the whole insurance industry standard and practice. I'm not sure I read Judge Gertler's decision as resting on a resolution on that basis. So,
yeah. Unfortunately, Your Honor, that reflects kind of the shifting sands that are the result of the changing arguments that Peslick has made. Peslick suggests now on appeal that what is dispositive of this case is that Cantex and RBR reached an agreement that put to its intended use would have a special meaning. Well, certainly the deposition testimony of Cantex, declarations from the parties, is material that's pertinent to determining whether that agreement was ever made. And we ask that Your Honors allow Cantex the opportunity to develop that evidence and present that evidence, and it will demonstrate that the trial court's judgment here was wrong as a matter of law. I'll reserve the remainder of my time. Thank you.
Thank you, counsel. Mr. Welker? Yes.
Good morning. May it please the court, my name is Chris Welker, and I represent the appellee here, Princeton Excess and Surplus Lines Insurance Company, or Princeton for ease of reference. As has been illustrated already, the key dispositive issue in this case centers on the significance of the critical milestone, substantial completion, under the construction contract.
But the policy doesn't use substantial completion.
It does not. It uses intended use, and counsel for Cantex suggests it's mere happenstance that the policy's use of the word, or of the phrase intended use, matches perfectly the construction contract's use of the phrase intended use. It is not mere happenstance. That is a critical milestone recognized in the construction and insurance industries that represents the moment in time when rights and liabilities and risk pass.
When you say recognized in construction and insurance industries, what's the evidence or the support for that?
That would be the secondary authority, the AIA commentary that was provided with Princeton's appendix. It talks of how the form contract, the AIA form contract that was used by RBR in this case, was the result of a collaboration among contractors, owners, subcontractors, and insurance professionals to arrive at a very meticulous system that explains the significance of substantial completion.
But if you're relying on that, doesn't that tend to support Mr. Davis's argument that he should have been given an opportunity under Rule 56 to come forward with contradictory evidence to avoid summary judgment?
Your Honor, respectfully, I don't believe so. The AIA commentary is simply a secondary legal authority. It's not evidence. It's not factual evidence. The factual evidence in this case that's critical is the contract, the construction contract entered into between Cantex and RBR. Legal commentary is secondary legal authority that helps elucidate the form contract that was used here. And that gets back to the point that Cantex had an opportunity. And the irony here is that Cantex requested that the trial court convert the motion to dismiss to a motion for summary judgment, unlike the case Cantex relies on where the plaintiff put in extraneous material. Here,
Good opinion, you would agree.
absolutely.
I take issue.
Completely distinguishable here, in that the plaintiff in that case put in all the evidence, and then the defendant was not given an opportunity. Here, Cantex had full opportunity. Cantex requested that it be converted, provided the evidence it thought would support its position, and never requested, as Your Honor points out, Rule 56F relief. So it waived it.
If the industry got together to create the AIA forms, which I don't doubt, why didn't the industry go over to the ISO and say, you know, we need to adjust your standard CGL form here a little bit, and under the definition of products completed operations hazard, and we're going to change sub C 16A2C to say when that part of the work done at a job site has been put to its intended use, or substantial performance in the event your contract is an AIA standard form contract. It doesn't say that.
They understood intended use means intended use in the AIA contract.
How do we know they understood that? Where's our evidence?
Well, just use of the same exact phrase. The policy covers intended use, or it applies once the project is put to its intended use. If the court will indulge me to read from the AIA Certificate of Substantial Completion, which the court already referenced, just one sentence from the top. Now, of course, the certificate's required by the contract. It's signed by Cantex as owner accepting the project. The first paragraph, the second sentence states, substantial completion is the stage in the progress of the work when the work or designed portion is sufficiently complete in accordance with the contract documents so that the owner can occupy or utilize the work for its intended use. That sentence makes intended use synonymous with substantial completion. Substantial completion is defined as that point in time where the owner can now put the project to its intended use.
I would be more comfortable with your position. I've got that highlighted here, as you can see. I'd be more comfortable with your position if there was some reference in the insurance policy language to these AIA documents.
Well, Colorado Casualty is an important case here. Counsel referenced Colorado Casualty. Colorado Casualty perfectly supports Princeton's position here. If you look at Colorado Casualty, it dealt with two exclusions, the ongoing operations exclusion and the completed work exclusion, or your work exclusion. Now, in Colorado Casualty, the only Arizona case that deals with this type of exclusion. In that case, the exclusion was at issue. In other words, the insurer was saying once the work is completed, there's no coverage. So there wasn't an exception, it was just an exclusion. And so the insurer wanted the exclusion to apply. But critically, there were two exclusions, the ongoing operations. And when interpreting the ongoing operations of the policy in Colorado Casualty, this court looked at, well, what does the construction contract tell us are the ongoing operations? Let's look to the construction contract to be informed on what those ongoing operations are so we know if they're covered by this insurance policy or not, or rather if the exclusion applies. Same thing with put to its intended use. Colorado Casualty looked at what does the construction contract require the contractor to do so we can determine if it's been put to its intended use.
I guess I'm kind of, counsel, are you getting back now to construing just the language of the contract and the policy? You kind of are talking about some of the industry practice and so forth. Where are you right now in your argument?
Well, that there is authority in Arizona that you do look and you can rely on the language of the construction contract to understand the terms used in the insurance policy. And again, I would suggest that that is in harmony with the industry standard, that the industry standards set it up this way, that you do look to the construction contract when you have a term such as intended use.
This is a variation, I think, on Judge Gimmel's question, but looking at 16A2, A, B, and C, it becomes problematic in my mind when A and B both specifically talk about as called for in your contract, and then C, that language is conspicuously absent. And when we're construing statutes, we ascribe significance to that. We think, well, if the legislature had wanted to carry forward that provision, it would have put it in here, and it didn't. And so, you know, if C said when that part of the work done at a job site has been put to its intended use as contemplated by your contract, you'd have a much easier argument. But I'm wondering whether we should ascribe significance to that omission in C.
I do not believe there is significance in that omission. This entire section, that's of course one subsection of a subsection. The entire section is dealing with the construction contract. Let's look to the construction contract. Intended use is defined in the construction contract. The industry understands that. The AIA form states it, that substantial completion means the point in time you can put the project to its intended use. So I would suggest that the use of intended use in C is in harmony with the use of intended use in the AIA form construction contract. It provides certainty. It provides a bright line rule. The industry understands that this is when.
But what Mr. Davis argued was these are alternatives. So you have under Section 2 generally, however, your work will be deemed completed at the earliest of the following times. So that tells us there, you know, it could be one of these sections below, and A and B talk about when the work is completed in the contract, and then subsection C doesn't mention the contract at all. It uses arguably different language. So how do you construe those together to all refer back to the contract? In other words, just kind of dovetailing on Judge Downey's point, because she writes these fantastic opinions, and I need to be able to try to get in on some of that.
I understand.
Excellent reasoning. Is it conspicuous for the absence of the reference to your contract in subsection C, given that these are alternatives?
No, I believe the court in Colorado Casualty showed us the way. Colorado Casualty looked at the construction contract and said, okay, we have a term, a specific term in the policy. Does that same term get defined or elucidated in the construction contract? That's a reasonable way to look at this policy. The policy is meant to cover this construction project. Does the construction project inform us of what intended use means? And that is a reasonable interpretation of that provision.
I think what you're saying makes sense, but the issue as I see it is not whether the policy may, whether the contract may provide some meaning to intended use as it's used in the policy. It may do that. It probably does do that. But is it the only meaning such that summary judgment is validly granted on that without the other side having had an opportunity to present contrary evidence?
Well, Your Honor, I believe they did have the opportunity, and they presented the evidence that they thought would be helpful, but
At that point, it had not yet been officially declared a summary judgment, right?
correct. It was declared at the oral argument, at which point counsel for Cantex could have asked for Rule 56F relief. The court in the Edwards versus Board of Supervisors case, which we cited, said if a request for Rule 56F relief is not made, it is waived. So if counsel felt there was a need for additional evidence, it should have requested Rule 56F relief.
What was that case again?
Edwards versus Board of Supervisors. But no evidence, Your Honor, and this is the most important point, no evidence can vary or contradict the plain meaning of the words used in the construction contract that tells us exactly what intended use means. Substantial completion is the point when the project can be put to its intended use. The construction contract and the certificate of substantial completion are both very clear on that point. And the policy, again, the policy behind this is very important.
Well, hold on to your policy thought for a minute, please. We're talking about the differences between A, B, and C in this definitional portion defining the product's completed operations hazard. And as both of my colleagues have pointed out, A and B reference your contract and C does not. And it looks like, do you agree that C is talking about a part of the work done? A and B A is talking about when all the work under your contract is done, and B is talking about when all the work under your contract has been done at a particular site, and now C seems to be talking about partial work the work being partially done at a particular portion of the work. Says, in other words, I'm asking you, I guess, what does it mean when that part of the work done has been put to its intended use?
Well, again, using the phrase intended use, it means substantial completion. It could be part of the work, it could be the entire project, but it's substantial completion.
So your position would be that the portion at issue here of the concrete slab could have been declared to have been in substantial completion and therefore put to its intended use. That could have been done on a piece-by-piece basis. Didn't have to wait for the whole thing?
It could have been done. The construction contract allows it. It allows for partial substantial completion or substantial completion certification of a portion of the work. There's the process to go through. There still must be inspection and certification by the architect that it's fit for.
Were they not, in fact, using it for its intended use under a temporary occupancy permit?
Not for its intended use. There was some use under a temporary occupancy permit and the construction contract in section 9.9.1.
I wonder what that use was. They were storing things on it, they were driving on it, they were walking on it. Aren't those its intended uses?
They're not the intended uses because the phrase intended use is defined only upon substantial completion. And whether it be part of the work or all of the work, it has to go through the substantial completion process. The provision in the contract that they were operating under, section 9.9.1, allows for partial use. In fact, that's what it is referred to, partial use. That's what they were operating under, not intended use. In fact, under that provision that allows for partial use, it indicates that when the contractor believes that portion that is being partially used is substantially complete, it shall go through the process. It will request the inspection and the certification, and it will ask the architect to certify that that portion is now ready to be put to its intended use.
You said 9.9.1, right?
Correct. Yeah. 9.9.1, the heading of 9.9 is partial occupancy or use. That first section, 9.9.1, discusses the ability to partially use a part of the project, but it's still not the intended use. It then goes on to define or to describe the fact that there can be a partial substantial completion.
Now, in this AIA document A201, the construction contract basic provisions form, is there a specific definition of intended use, or are we simply dealing with the substantial completion language that uses the phrase intended use?
There is no separate definition of intended use.
Doesn't that make it more remote that that should be deemed intended use under the insurance policy?
No, not at all. Because it's so clear that substantial completion means the moment in time when it can be put to its intended use, that works in perfect harmony with the insurance policy. Which brings...
You were going to say something about policy
Yes.
when I interrupted you.
No, that's fine. And that brings me right back to the policy, the public policy behind this. The commentary, the secondary authorities that we cited and put in the appendix note that substantial completion is the critical milestone in a construction project. And why is that? Well, because that is the point in time when many rights, liabilities, risks transfer from the contractor to the owner. Specifically, there are many, but the contractor's warranties to the owner begin upon substantial completion, not before. So only at the time that the project is put to its intended use or at substantial completion do the contractors, RBRs, warranties kick in to the owner. At substantial completion, or when the project is ready to be put to its intended use, is when the possession of the property officially transfers from the contractor to the owner. When the owner becomes potentially liable in premises liability, that happens at substantial completion.
I can understand the idea that all of these changes and shifting in responsibility and liability and ought to perhaps occur at the same time, but I'm not entirely, at least I'm not immediately persuaded that the exception to the exclusion in the faulty workmanship provision has to be triggered at the same moment.
Well, it goes to the certainty, Your Honor, the public policy of certainty. Cantex suggests that any use of that part of the work, regardless of the time that it occurs in the duration of the project, regardless of its relationship to completeness, any use qualifies. We're talking about products completed, operations hazard. We're talking about when the project is complete, then this insurance may apply.
Standing in the shoes of the insured, why wouldn't they argue that this what I call the faulty workmanship exclusion is, which under the very terms of the ORIC policy, it's removed when, with respect to property damage included in the completed operations hazard. So why wouldn't they argue to have that occur sooner?
Well, of course they want it.
Such as their temporary, and what would be wrong with that?
Well, this gets right back to the policy rationale. This is general liability coverage. This is not, and we've pointed this out in our brief, this is not a performance bond issued by a surety. The purpose of a performance bond by a surety, of course, is to cover defective work. This is a general liability policy to cover, as some of the authorities we cited make clear, this is to cover occurrences
like
after
water
the project
damage.
is completed. An example would be you build a faulty building, and after it's done, it falls over and destroys a house or a car. Well, that's an occurrence after the product's been completed.
Yeah.
It's not a performance bond designed to correct defects in the work while the work is ongoing. That's the role of a surety. That's the policy reason why substantial completion is the critical milestone.
That was our 9 o'clock case.
I heard.
But again, referring to tenets of statutory construction, we don't normally look at policy unless we find terminology to be ambiguous. So why are we concerned about these policy issues?
Well, there is no ambiguity, I would submit, in the policy.
Then we shouldn't look to policy.
Well, the policy supports the plain reading of the policy in conjunction with the construction contract. The policy explains why the same phrase is used, that it's not just happenstance. Cantex suggests there's absolutely no connection. It's just coincidence that the policy says intended use and substantial completion is defined as when it's put to its intended use. Cantex suggests that's mere happenstance. And that's just not the case. So public policy supports and strengthens and explains the significance of substantial completion and why those phrases are used consistently, and why that critical milestone of substantial completion is so critical. I see my time is about up. If there are any other questions.
You're happy about that, right?
Thank you.
Thank you, counsel. Mr. Davis?
Thank you, Your Honors. Judge Gemmel, you asked whether the use to which Cantex put the pavement was the intended use. The answer to that is very easy. Yes. Yes, it was.
But how do we know that? I'm just figuring, I'm just using common sense, which my colleagues have tried to train out of me.
You should and can use your common sense here, but you could also look at the declaration of Randy Cates. There's been the assertion that it's widely recognized that intended use incorporates this substantial completion standard. If that were the case, there would be case law that supports it. There is not. Furthermore, if the insurer intended that put to its intended use in the insurance policy incorporate requirements for substantial completion, they should have said so. And the rules out of this court and the Arizona Supreme Court make that quite plain.
Excuse me for interrupting, but trying to use your time quickly here. What evidence would you have presented? I don't recall learning that in your briefing. Possibly I missed it. But what evidence would you have presented if you had been, as you say, if you had been given the opportunity more than you were? I mean, what would you come in and say? Here's Mr. Smith, the dean of the ISO CGL policy, and he says, "Oh no, intended use means X, Y, Z."
I would have brought in Oric, who wrote the insurance policy. I would have brought in RBR.
Oh, they didn't write it. It's an ISO policy.
I would have brought in RBR, the insured, and asked RBR as a contract of adhesion, what were your reasonable expectations? Did you, as you noted, think that completed work covered work that you had completed, like this pavement, once it was put to its intended use?
It's not terribly likely that they had a specific thought process regarding subsection 2C.
Your Honor, I see my time is up. May I finish answering your question?
Yes.
My point is, of course, I suspect they had a general concept of when something is completed, the insurance and maybe other liability issues change. But I would doubt that normal insured would have focused on the grammar and language and plain meaning of subsection 2C.
I doubt they would. I think that RBR would say it had the reasonable expectation that it was purchasing coverage for its completed work. And I think RBR would say, and I think that the facts here suggest that RBR believed that there was coverage when it had completed its pavement work. Because let's just look at the common sense here. If RBR knew that its pavement work was not covered, that any damage resulting from faulty workmanship to the pavement would not be covered, would RBR allow Cantex to drive tractor trailers all over the facility? Of course not. Thank you, Your Honors.
Thank you, counsel. We will issue a written decision in due course. Court's in recess.